we may need a bigger table. We'll hear from the appellant.
Good morning, Your Honor. My name is Richard Graves. I represent the petitioners and appellants in this matter, Frank and Tina Reed. I'm of the Knoxville Bar, and I'd like to reserve 5 minutes for rebuttal.
That'll be fine.
This is an appeal of my client's challenge to a variance, a height variance that was granted by the Town of Louisville Board of Zoning Appeals in May of 2022. And so this court's standard of review is essentially sitting in the same position that the trial court is. And in general, this is a very deferential standard of review as an administrative body. However, I think practically the fundamental determinative question in this case is whether the record contains material evidence of unique property characteristics necessary to justify a height variance to the applicant here. And I say that based on a litany of case law that describes challenges to variances. And the general line of reasoning from this court is by statute, the BZA is empowered to grant variances only when unique property characteristics exist. And so to the extent it grants a variance when those characteristics do not exist, the BZA is acting in excess of its statutory jurisdiction, which that's a ground for overturning administrative action. Also, if there's lack of material evidence to support it, it also makes the BZA's decision arbitrary and capricious. So, however the standard review is couched, fundamentally, it's a case of whether there's material evidence to support a variance here. In going further, in search of that, I think this is really a tale of two matters. In one sense, it's very, very simple, we would contend. In the other sense, it's more complex based on some arguments raised by the respondents here. And the reason that we think it's simple is that, put simply, there's no material evidence in the record of any unique property characteristics necessary to justify a height variance here. And I say that very confidently based on the fact that both respondents conceded to the trial court that this is not an application where unique property characteristics make a height variance necessary. And the court itself acknowledged at the hearings that this is not a case where we have a problem with the tract of property. And so really that by itself, that ought to be the case. It should be easy. This variance is illegal, it was in excess of the BCA's jurisdiction, it was arbitrary and capricious. However, the trial court upheld the grant of a variance here based on another grant of statutory authority that the trial court characterized. I think a fair characterization would be called a special question authority. And that has its origin in Title 13, Section 7, Title 13, Chapter 7, Section 207, which sets forth various powers of boards of zoning appeals, among which is the authority to grant a variance. But there is also an authority for a board of zoning appeals to pass upon other special questions which they are authorized by a local ordinance to pass upon. So the trial court here held that the totality of the zoning ordinance grants the BZA authority to pass upon a special question of whether the applicant, William Madison, was permitted to build a structure in excess of the 14-foot height limitation by the zoning ordinance. And I think there's several problems with that. I think the first problem fundamentally is a problem with the record. And when I say a problem with the record reflects that the BZA considered, voted upon, and granted a variance application. There was no discussion of any special question authority that the BZA acted upon. And I think the pleadings of the parties, and back to the minutes, the case law from this court is that administrative bodies, their official record of their actions is their minutes. Similar to the rule that courts speak through their minutes and not through deliberative statements of transcripts out of hearing. So the record reflects that the BZA granted a variance, and as we'll get into that later. But moreover, the pleadings of both parties also acknowledge that the BZA granted a variance. Just to read the town's answer, in paragraph 10 of their answer, they stated that the only issue presented to and considered by the Board of Zoning Appeals was whether a variance from the 14-foot height limitation for the construction of an accessory structure should be granted.
Council, excuse me for interrupting. The zoning ordinance that controls here, does it grant the BZA plenary authority, broad authority?
I would say that the ordinance grants the BZA a host of authority. However, that authority fundamentally is controlled by statute. Now, the ordinance here does grant the BZA the power to pass a variance, and to the extent that the BZA has authority to pass upon special questions, that has to be read in the context of the BZA's separate authority to pass a variance. And I think that there's a key fundamental question that ought to be asked of the respondents here with respect to this special question authority.
With reference to the zoning ordinance, does it authorize the BZA to conduct administrative review of any order, requirement, permit, decision, determination, or refusal made by an administrative or building official? And if so, how does that impact the issue in this case?
Well, the BZA does have that authority to review decisions by administrative officials. However, that's not what the BZA did here. And just as an example, the BZA in its minutes granting this variance imposed conditions upon the use of property. It imposed, I think, two specific conditions. I think one, that the structure be sit back a little extra from the boundary line, and another one. But the zoning ordinance only authorizes the BZA to place conditions on property in two scenarios, one of which is for a special use application, which this is not a special use application, and the other is a variance, which this is a variance. And so whatever authority the BZA has, the only authority they exercised was a variance application, and that's evidenced by the very fact that the BZA placed conditions on the property. And I think it would be a telling question to ask respondents to address: where is the BZA's authority to rule on a special question and impose conditions on the use of a piece of property while carrying out that special question authority? It's not in the zoning ordinance, as best I can read it. But I also think just more fundamentally on the substance of this special question authority, the zoning ordinance and the statute separately describe the authority to pass upon special questions and the power to grant a variance. So what that means is that those are fundamentally qualitatively different grants of authority. What that means is that if the BZA did not have the substance before it to grant a variance, it cannot shoehorn the substance of a variance under the form of a special question.
Well, give me an example of a special question that you say would be distinguishable from a variance.
Well, that would have to be an ordinance by ordinance question, because the statute describes a special question as it relates to a special question upon which such board is authorized by a local ordinance to pass. Mm-hmm. But just as an example, off the cuff, you may have a question as to where is the exact, questions of interpretation of the map are in there, but is a, it's hard to answer an hypothetical in the context of this zoning ordinance, but in other zoning ordinances I've read, I've seen the BZA be granted power to review an application for a certain use if certain other conditions are met for such use, for example. But I think regardless, that question really doesn't even have to be answered to reach the ruling today, to understand fundamentally that that's a separate grant of authority.
Well, the trial court stated concede it's not a special exception, but it may be a special question. And then he stated the deciding variances from the terms of the zoning ordinance.
And that's the crux of the ruling that we're here to appeal today, that is erroneous. I see I'm out of time. I'd like to reserve the
No, you
balance.
still got your time. If it's running down, you don't have to keep talking, but you're not out of time yet.
Well, that may be the wisest thing to do.
That'll be fun. Now you're out of time. Thank you. We'll hear from the appellant. Will be more than one argument on this side.
There will, Your Honor. I am counsel for the Board of Zoning Appeals. I'm going to take 10 minutes. Counsel for Mr. Madison is going to take 5 minutes.
All right, thank you. So it'll be 10 minutes to start with.
Good morning. May it please the court. Brian Bibb of the Knoxville Bar on behalf of the town of Louisville, Tennessee, and the Louisville Board of Zoning Appeals. The issues on appeal, as I see it here, is not so much a dispute as to whether material evidence was presented to the board, but whether the board acted within the jurisdiction that it was conferred. It does not appear to be any dispute that there was a rational basis for the decision. The question is whether it was the correct rational basis, and whether that rational basis was within the scope of the jurisdiction conveyed to the Board of Zoning Appeals. And so I want to start with that issue, jurisdiction of a Board of Zoning Appeals. We cited in our case Whitmore versus Brentwood Planning Commission, which is a very helpful opinion that lays out the two sources of BZA authority. Of course, it derives initially from state statute, 13.7.206 and 13.7.207. And under that state statute, BZAs can make special exceptions. That's not applicable here. Special exception use is a doctor's office is in a residential area where there may be an additional proof that needs to be made. Interpreting zoning maps, we're not doing that here. Passing upon boundary lines, we're not doing that here. Authorizing variances, that's an issue in this case. Deciding other special questions as authorized in the zoning ordinance, that's an issue in this case. Deciding appeals from decisions of a municipal building commissioner or other administrative official, that's an issue in this case. So 13.7.206 and 13.7.207 set the outer boundaries of what authority can be conveyed to a BZA. And then, as the Court of Appeals, as this court said in the Brentwood case, state law permits but does not require city commissions to empower boards of zoning appeals to perform those 6 functions that I listed. So we start with 13.7.206 and 207, and then we look at the zoning ordinance. How much power and under what conditions does the zoning ordinance authorize its Board of Zoning Appeals to act within the scope of that broader group of authority that is conveyed by state statute? So, how does the Town of Louisville zoning ordinance authorize the board to act? Relevant to those 3 issues that I discussed earlier, it authorizes them to conduct administrative review of any order or requirement, permit decision determination or refusal made by an administrative or building official under the zoning ordinance. In this circumstance, the applicant filed his application for a building permit to the building official. That application was denied. The building official directed the applicant to the Board of Zoning Appeals if he wished further review. Second, to pass upon special exceptions, again, this is not a special exception use, or special questions the board is authorized to consider under the zoning ordinance. That was the language the trial court looked at.
Well, let me ask you this. I agree that they definitely had the ability to consider special questions, but is that what was pled in this case, or was a variance pled?
And I'm going to be frank on that. Variance is the language that was used in the application. I think one factor that's important to consider is that all parties were unrepresented before the BZA, no attorneys involved. Mr. Madison was told by the building inspector that he needed to file for a variance, so Mr. Madison, that's the piece of paper he filled out and submitted.
And that is what he got, right? A variance from the stated height limitations.
That's correct. That's what the minutes say. The minutes, the language used by the board during the meeting was variance. The language in the minutes was variance. And we certainly take the position that that was a legal variance grant within the scope of authority.
So where do we get a special question?
That began, frankly, with Judge Dugan and sort of the language that he saw in the ordinance. And that was something he asked for additional briefing on. So we came before the court for the merits hearing on certiorari, and then we get up to argue, and Judge Dugan says, here's some other issues I'd like you all to address. He dispatched us to do some additional briefing on that. So the reason why special question is relevant, to try and get to your specific question here, is because of the language of the precise zoning ordinance that was considered, which is section 11507.2.a, dealing with height variances. The Board of Zoning Appeals interpreted that ordinance as containing a degree of permissiveness and discretion based upon the language in the ordinance. And so the Board of Zoning Appeals has, and of course in certiorari we're considering the dispute before the court, but the board explained that it had interpreted this, and it has the discretion to interpret its own zoning ordinances. It had interpreted this ordinance to have a factor or a modicum of discretion included in it. So that's the special question. The special question is the specific distinction placed in the zoning ordinance. A special question is the zoning ordinance has some decision that the BZA must make. It comes before the BZA must weigh the factors, attempt to do justice to the applicant, and in this case the opposing party, and reach a decision that it feels has merit. And I suppose to address my friend's concern about the fact that conditions were placed on this here, I'm not aware of anything that would restrict a BZA from placing conditions on a permit grant. Of course, the court's probably familiar with Nolan and Dolan, which is a federal precedent that says you can't place overbearing conditions upon a grant of a administrative permit, but otherwise, BZAs are there to try and reach a fair resolution. Here we had neighboring property owners who had some concerns about this. BZA is trying to reach a resolution. How do they resolve that? Well, they require screening. They say, all right, if you're going to build this building, you're going to have to fence it. If you're going to build this building, we're going to require you to increase your setback. That's the special question that the BZA was addressing.
I'm still not sure I understand what was the special question in this case.
The special question was whether or not the BZA would grant would grant discretion or permission, maybe the right word, to the applicant to exceed the height requirement.
Whether or not they'd grant the variance.
And I think ultimately what this comes down to, and again, we've briefed this and we've cited cases. The opposing counsel has discussed physical characteristics of the land. The law says that's the primary characteristic. The law does not say that is the exclusive characteristic. The courts may grant a variance where there is a showing of practical difficulties, unnecessary restraint, or undue hardship. We feel that there is some material evidence in the record to support that. Setting that aside for the minute and not conceding that this was not a proper variance grant. I think what we're doing here ultimately, and what opposing counsel is suggesting to the court that we ought to do, is set aside the overarching question was this within the grant of discretion? And I think undoubtedly it was. But does it matter that they put a word on it? Does that change the difference? In other words, because they've called it a variance, does that make it in excess of authority?
So you're basically saying the label was incorrect, but what they actually did was within their rights as a special question.
Sort of. I guess let me throw that back at you like this. No, we do not concede that this was not a variance. Okay, we maintain that this was a properly granted variance, but in the alternative, even if it wasn't.
Let me stop there.
Yeah.
How is it a properly granted variance? You don't disagree that the language about it, the language is specific to problems with topography and things like that, and that's not in dispute, right? No evidence was presented to support that.
This is the dispute that I make with that point. Absolutely no, we do not contend that there was a hill or physical factors underneath the building that necessitated the change. But, and we've cited cases to this effect in our brief, we certainly do not concede that under the language of 13.7.207, a variance can be granted where there is a showing of practical difficulties, unnecessary hardship, or unfair restraint, independent of those factors. And we've cited cases from this court that support that proposition. I concede that that's the primary factor. In your usual variance grant, yes, that's the main issue the courts are going to consider. But that's not the exclusive factor. It may be the main factor, but that does not say that a court cannot grant a variance where there is an adequate showing. And of course, on certiorari review, the level of review, we may have made a different decision if any of us were sitting on that BZA. We may have voted differently. But that's not the standard on certiorari. Was there any possible reason to support the decision? Was there any material evidence to support the decision? Did I answer your question as best I can? Okay.
What's the material evidence that supports granting of the variance?
The material evidence, and this is maybe something my co-counsel may want to elaborate on, the material evidence that supported the granting of the variance, and again, I don't think this was even in dispute below, was essentially engineering issues. Engineering issues with safety of the safety and suitability of the roof in terms of slope, based on the height of the roof. And I may be missing one. I think there was also some issue with the location in relation to the setback, but I may be missing one.
I'm just curious why the roof on this building was unsafe. Would have been unsafe if they'd stayed
I think it
with
was a
the
snow
ordinance.
load issue. I will tell the court that was hotly debated before the BZA. And there is certainly evidence that the BZA carefully considered, heard competing evidence. This was not a shotgun variance.
Is there, one last question,
Sure.
your time's up. Is there anything in the BZA record that says to indicate that they thought they were answering a special question or that they were just addressing the variance?
I guess my answer to that would be yes, and based upon Chairman Swiska's explanation of how they treat requests under 11507 of the zoning ordinance. In other words, that they view that as a matter that has been conveyed to them upon which to exercise discretion. Does he use the term special question? No, but I think that is where that comes from.
Thank
The court
you.
has no more questions. I appreciate your time.
Thank you.
Please the court, good morning. My
Morning.
name is Bart Williams, law firm Hodges, Dowdy & Carson. I have the privilege of working with Wayne Klein on this matter. We represent the appellee William Madison in this case. Mr. Madison is in the courtroom with us. Your Honor, I guess I would start by addressing directly the question that you just asked to our friends here from the Knoxville Bar. What were the reasons? So the reasons that's in the record that would justify this decision by the BZA is that there was a need to build a structure of a certain height, primarily a certain door height. In order to have a certain door height of 12 feet, it needed to have a certain room to account for the pitch of the roof. Okay, so that's really what it came down to. And there was extensive debate in the record and the transcript and the oral transcript about those issues. People arguing about why this was needed versus another, and Mr. Madison came to the BZA meeting with a whole bunch of information for the BZA's consideration to make that decision. So I respectfully submit that there's no question in the record that there was material evidence for the BZA to make that decision. Now, we are here today because Mr. Madison was allowed correctly, we contend obviously, to build a structure on his own piece of property to store his own belongings. Something his neighbors very much did not want him to do. And I would submit that once you dig into the record, you'll see that there are all sorts of reasons for why that were proposed for why he should not be able to build this structure. Things like what would it do to the environment? There are untagged vehicles on the property. We don't like the junk in the yard. All sorts of stuff that have nothing to do with what ultimately the parties settled on. And what I submit to you is that after all of the, I also point out that the petition for certiorari that initiated this case in the Blount County Circuit Court initially relied on the argument that the zoning, quote, does not permit either junkyards or automobile boat repair shops in the R1 zone. A vast array of things to try to get this man from not building his structure on his property. After the case developed, what ultimately settled on is what they thought was the best way to get to the Tennessee Court of Appeals was that his building was about this much higher than what somebody said the rules should require. And so that's, when we get down to the nuts and bolts of the issues, that's what we're here about. So I could probably talk for way more time than I'm going to have about the fine legal arguments that I think are in the record and briefed by the parties, but I want to take this time to highlight the practical reality of what Mr. Madison was facing and what he did to get to this point. Like was pointed out earlier, Mr. Madison wanted to build a garage. He's acting in a pro se capacity. He wants to do the right thing. He files his building permit. The building codes enforcement officer says something to the effect of, everything looks good, but I think what you got to do is I'm unsure about this. There was one vague ordinance, which is briefed thoroughly before the court, that I think you need to get the BZA to rule on that. So that's what he does. You need to get the BZA to rule on that. How do I get the BZA to rule on it? Well, you file a variance application. So he fills out a form that asks for a variance to get the BZA to rule on the issue. So is there anything in the record, Your Honor, that specifically references special question? Those terms are not used, but I think the context as a whole, again, the practical reality is that what these people were doing was they faced a zoning ordinance. They said, I'm not sure what this says. We have some discretion. We need to address this question that was caused by the interpretation of the zoning official. Now, a bigger issue on this is we obviously contend, and it's outlined in the brief, Mr. Madison's case, is that this zoning ordinance does not put a cap on the height of this structure. It just doesn't. A plain and ordinary reading of the zoning ordinance, the height impacts the setback requirements. That's what it does. Now, it could have been very easy, I respectfully submit, for the officials to put a cap on the height of that structure. They could have said, no accessory structure shall exceed 14 feet in height. That's just not what it says. It's in the section under location. It fits with the building permit application that says, look at this rule to make sure you get your setbacks correct. So if we take a step back, we say, first of all, this zoning ordinance didn't even prohibit this building in the first place. Now, the way...
Counsel, for interrupting. Did the BZA have the authority to impose conditions?
Your Honor, that's a good question, and the reason I actually thought about this in preparation for today, the ultimate answer to that is I don't know, because Mr. Madison didn't contest it. He agreed to them. He's going to comply to the conditions. So that was never put before the trial court, and is not something that he contested. Is it certainly possible, sure, that those conditions were invalid? And if Mr. Madison wanted to contest those, that may have been an issue. But ultimately, like my colleague from the Knoxville Bar said, you know, they put conditions on there. Mr. Madison didn't take issue with them. He said, I'm going to comply with them and move on with my life. So, again, I think the practical reality, that's another point that Mr. Madison, what he was dealing with was, I want to build my garage. This is what they're saying I need to do. I see that I'm out of time, Your Honor. Unless Your Honor has any other questions, I'll stop.
I hear none.
Thank you for your time and consideration.
Hear from the appellant, rebuttal.
I'd like to first address the newfound interpretation argument, and I say newfound because Mr. Madison's answer, which he was represented by able counsel, described the BZA's action as, quote, simply stated, the variance application was to allow a roof peak of 21 feet instead of the code designated 14 feet, close quote. Now, it's a question of law. I'll concede that, not necessarily a fact. But, you know, Madison's answer is also sworn to, unless he's judicially stopped from arguing anything in contradiction of his answer, including this argument that what the BZA did wasn't really a variance.
But that doesn't prohibit us from reading the statute and making the same conclusion. So I want you to talk about the statutory
Sure.
language and how it does seem to say that if it's going to be 14 feet or lower, it can be as close as 5 feet from the rear property line.
Well, here's what the statute says. First, the statute says, or the ordinance says, only explicitly identified uses are permissible in the residential district. That's section 11-701, subsection 3. And then it does explicitly identify customary accessory buildings. And then, quote, subject to the requirements of section 11 of 507. And then section 507 that says, except for general farming structures, accessory buildings not exceeding 1 story or 14 feet in height and occupying less than 20% of the rear yard, I'm paraphrasing, may be located as close to 5 feet from the property line. So unless the structure complies with those requirements, it is not expressly permitted and thus prohibited. And so reading that, I think the language is expressly clear that there is a 14-foot height limitation. And I think both the town acknowledged that in their answer, which, by the way, the town presumably authorized the filing of that answer. And so there is a question in this case of how much, if any, deference we have to give to the Board of Appeals or Board of Zoning Appeals. This court recently in North Shore said the interpretation of a zoning ordinance is de novo. It's a question of law. No deference is necessary. We also have reported decisions going back to the Brentwood-Whitmore case that says, look, zoning ordinances interpretations in the first instance are matters for local boards to decide. And as long as there's a fairly debatable there, or the board has a reasoned basis, we're not going to set aside their interpretation. So to the extent that there is any deference here, the actual interpretation of the BZA as shown in their minutes, which is their official record, and their answer is that, yeah, there's a 14-foot height limitation that you need a variance from. Even Mr. Madison's counsel concedes that no variance is necessary if there's no 14-foot height limitation. As to the comments of Mr. Swicegood that they reference, I think this is critically important. Mr. Swicegood does not speak for the BZA. BZA speaks through its minutes. And I think let's just pretend, and it's a completely different scenario, but let's just pretend Mr. Swicegood says, I'm going to deny this application because I don't like the applicant's race, sex, creed, national origin, etc. And then there's a 5-0 vote that denies the application. Is Mr. Swicegood's comment binding upon every member? No, it's not. And I think that's appropriate. Lastly, this any possible reason standard, again, in North Shore, the North Shore Court addressed this. This is a quasi-administrative action. The any possible reason standard is for a review of legislative decisions, which this is not. This court held in North Shore, look, the any possible reason standard for review of legislative decisions does not permit us to uphold quasi-judicial action on a ground not actually raised below. That is just pure waiver. And so the any possible reason standard is not applicable here. There's one other point that, thank goodness it's highlighted. Practically what the BZA is trying to do under their special question is rewrite the zoning ordinance as they see fit in a situation as they deem proper. And I think that's a separation of powers issue. I think the Tennessee Supreme Court in Reddick v. Smith, a 1964 case, noted that the BZAs as quasi-judicial bodies do not have, quote, legislative prerogative, close quote, to practically rewrite a zoning ordinance through a variance application. That is exactly what will end up happening if this is upheld as a special question. That's all I have.
Thank you. Court appreciates oral arguments of all counsel today and then your briefs on this. Thank you very much.